All right. Here it is for the Fulton County DA Atlanta Judicial Attorney's 9-7. The Honorable Judge Scott McAfee is presiding. Court will now come to order. Thank you for sitting.
All right, let's go on the record with 23 SC 188947. Who do we have as lead counsel for the state today?
Good afternoon, Judge Nathan Wade, Special Prosecutor for the state. Here present at the council table with me, I have Executive District Attorney Daisha Young, Deputy District Attorney Will Wooten, and Special Prosecutor John Floyd.
All right, thank you, Mr. Wade. And for Mr. Chesborough, who's lead counsel today.
Good morning, Your Honor. My name is Scott Grubman. I'm representing Mr. Chesborough, and with me I have co-counsel Manny Aurora.
All right, and Mr. Grubman, have you received express authority to waive your client's presence today? All right. And who do we have for Ms. Powell?
Brian Rafferty on behalf of Ms. Powell, Your Honor, and I have received express permission to waive her appearance.
Okay, thank you, sir. All right, so just a few preliminary thoughts before we kick things off. To be clear, the scheduling order we entered for Mr. Chesborough earlier last week didn't contain any kind of a ruling on severance. So the plan would be to try to resolve as many of these issues as we can this week and to begin entering scheduling orders for the remaining defendants by either the end of this week or the early next week. So with that, is there anything else we should take up before diving into argument? Mr. Wade?
The court had asked the state to be prepared to respond in its notice of the hearing, asked the state to be prepared to respond to a certain questions, a good faith estimate in terms of time, how many witnesses, and so forth. We're prepared to do that if the court would like.
Okay, well, let's do that during your argument in response after we hear from defense on their motions. Okay. Okay, so I think just taking it alphabetically, there were two motions we'd scheduled to be heard today from Mr. Chesborough. So, Mr. Grubman, floor is yours, and I think the idea would be to try to limit this to 20 to 30 minutes. We'll see where the discussion takes us and go from there.
Would Your Honor, would it be acceptable for Your Honor if me and my co-counsel, Mr. Aurora, there's kind of a natural split. I'd like to talk about the kind of groups of facts that will go to both of our motions, both the motion to sever counts and the motion to sever from Ms. Powell. I believe the court indicated you would want to hear arguments on both. And then Mr. Aurora will talk more specifically about the statutory factors, if that's okay with Your Honor. And it won't take we won't take up more time than any one of us would have.
Okay, have at it.
Thank you, Your Honor. Your Honor, I want to start off by saying we recognize this is a RICO prosecution. We recognize that, and we do recognize that part of RICO is, providing prosecutors, at least the state would argue this, and there is some case law to suggest this, providing prosecutors with a little more ability to bring in conduct that's maybe broader than had they charged a direct crime. For example, in this case, there are, I would argue, 3, 4, or 5 separate alleged conspiracies really contained in one alleged conspiracy in this indictment. Mr. Chesborough is only concerned in terms of the evidence or allegations with what I'm going to call the alternate elector alleged conspiracy. The allegations contained in the indictment, and of course I'm not saying that I believe they are true, but accepting them as true, shows that Mr. Chesborough, at most, was only involved in that aspect of the conspiracy. Specifically, the allegations showed that Mr. Chesborough received approximately 18 emails, all in his role as an attorney for the Trump campaign, asked to opine on the application of the 12th Amendment to the United States Constitution and the Electoral Compact, and then several other emails. Most of those additional emails were simply transmitting the memos that Mr. Chesborough wrote that are alleged in the indictment, and one or two other emails to certain state officials discussing the logistics of how to go through the Electoral Compact. So that's what I'll call the alternate elector alleged conspiracy. Mr. Chesborough has been indicted as part of that conspiracy. He's alleged to be part of that conspiracy. Obviously, we will defend those charges, but that's conspiracy A, if you will. Then there are two or three other conspiracies. With all due respect to Ms. Powell, and nothing I say, of course, in this should indicate whatsoever that I'm commenting on the evidence against Ms. Powell. And I apologize, I know that's not Ms. Powell, but her representative, Mr. Rafferty. Ms. Powell is alleged to have engaged in a conspiracy, again, just accepting the allegations and the indictment is true, dealing with the computer systems down in Coffee County, Georgia. And those computer systems, as we allege in our indictment, Mr. Chesborough, or I'm sorry, in our motions, Mr. Chesborough is not even alleged to have undertaken anything, even remotely related to the Coffee County conspiracy, which I'll call it. Then there's a third alleged conspiracy. And that third alleged conspiracy, I'll call, I don't necessarily want to use her name because of the circumstances, but the poll worker conspiracy, where there are allegations that certain individuals named in the indictment went and tried to apply some pressure tactics to a certain poll worker that I believe works here, lives here in Fulton County. That is also a conspiracy that in no way, shape, or form involves Mr. Chesborough. And again, that's not my defense take on it. That's according to the allegations in the indictment. Now, again, as I started off, Your Honor, I understand that RICO does provide flexibility. What I would argue to the court, however, is that, of course, RICO does not overrule all of the rules and statutes and constitutional provisions that ensure that Mr. Chesborough not only has a speedy trial, which of course he's already demanded, but a fair trial. And Mr. Aurora will talk more about the detailed case law, but it's pretty clear here, Your Honor, that if this case were allowed to go to trial with either all 19 defendants, which obviously it seems like that's probably not going to happen, but even with just Mr. Chesborough and Ms. Powell, you're going to have two cases in one. You're going to have, and I'll be very interested to hear the government's good faith estimate of evidence and witnesses, but you are going to have days, if not weeks, God forbid, maybe even say months, given some experience in some other high profile cases that are happening in this building under the RICO statute. You're going to have weeks, if not months, of testimony just related to the Coffee County allegations. And because, I mean, if you've just reviewing the publicly available information related to the Coffee County allegation shows that at least how the state indicted it, it's a alleged wide-ranging conspiracy involving various people, involving very specific allegations about computer trespass and the like. And then you're going to have a full trial, same trial, but somehow you're going to have another full trial within that same trial about the alternate electors. Now, I suspect that the government is going to, or the state, I'm sorry, is going to say, well, it's all connected with the same purpose, and therefore it makes sense to keep all these charges together and keep all these defendants together. But, Your Honor, I would ask you to please keep in mind that the purpose that we're talking about here, I mean, I guess you can say the purpose is to elect Donald Trump president. But if that were the purpose, and a prosecutor could use a purpose of that magnitude to try to tie together charges and defendants that otherwise have nothing to do with each other, then, you know, before we know it, millions of people, literally millions of people could have been charged in this conspiracy. These are totally separate cases, Your Honor, and I believe, as you'll see from my colleague, Mr. Aurora, who will get up and talk about the case law. Thank you for allowing us to do that, because he's a lot more on top of that than me. And as you'll hear from Mr. Rafferty, I suspect on behalf of Ms. Powell, it is going to significantly affect these defendants' rights to a fair and impartial trial. Why should Mr. Chesborough have to deal with a jury who's going to sit there for weeks, if not months, and listen to all of this evidence related to Coffee County and Ms. Powell? He's never been there. He's never met Ms. Powell. He's never emailed, texted, or called her. He's never spoken with her directly or indirectly. And although I'm not trying to steal the thunder from my colleague, Mr. Rafferty, on behalf of Ms. Powell, same is to be said for Ms. Powell. Why should Ms. Powell have to sit there for weeks and months hearing evidence and testimony about the alternate slate of elector alleged scheme when she's not even alleged to have any involvement in that? And again, for the third and last time, I'll go back to, I do understand that RICO exists, whether we like it or not. The prosecution chose to bring this case under RICO, although they could have very well brought this case specifically against individuals who are charged with individual crimes, but they chose not to, and that's their discretion. But, Your Honor, that should not override Mr. Chesborough's right to a fundamentally fair trial. It's in the state constitution, it's in the federal constitution, it's in the Georgia Code. And I'm really worried that allowing evidence related to all of these other counts and all of these other defendants, in particular, in this case, Ms. Powell, will very seriously jeopardize this. I think, as Mr. Aurora will make clear, it is clearly well within the discretion of the court, if not, as we argue, mandatory to grant this severance from Ms. Powell, and also to grant the severance we asked for related to the counts that don't affect Mr. Chesborough. So with that, Your Honor, I'm sure you'd like to hear some case law or supporting authority, so I will let my smarter co-counsel, Mr. Aurora, get up and deal with that. Thank you.
Good morning, Your Honor. Which motion do you want me to address first, the severance of the counts or the parties?
Yeah, why don't we dive into the severance of defendants? I think that's the one that we might have more to talk about.
All right. Well, I think, Your Honor, when you were a DA, probably battled against each other on some of these types of issues, trying to get severances together, but that was in another lifetime, I guess. I've tried to put most of the case law that we've got that's in the briefs, because in the end, I'll give you some more 2023 cases that just came down a couple weeks ago, both federally and in the state system. But in the end, I think a fair assessment is it's your decision. I mean, there's nothing that says if X then Y or if Y then Z. It's just basically you're going to have to weigh the options. Is it my voice or is it ringing?
There might be a little bit of a feedback.
Okay. So with regards to the severance, with regards to Ms. Powell, I'll go ahead and start the court off with Henderson versus State, and I've highlighted it for the state. And may I approach, Your Honor?
Sure.
That just came down about 2.5 weeks ago. And if you go towards the second to last page on the back, I've highlighted that for the court and for opposing counsel. So as you'll see at head notes 40, 41, and 42, like it says, everything's basically in your discretion. But in this case that just came down a couple weeks ago, what we were talking about is sort of highlighted in regards to sort of similarly the facts in our case, right? The first issue is going to be, is there going to be any confusion about the evidence? Are there conflicting defenses, antagonistic defenses? And in the end, is there going to be confusion as far as that goes? There will not be any antagonistic defenses because the two people don't overlap at all in the indictment or any evidence that I've seen. The issue is going to be what's the confusion, and one of the remedies is obviously jury charges. And in your case, the question becomes how many jury charges can you bring, can you provide to the the jury, as far as trying to understand all these types of things. So this case that I gave you is a RICO case involving gang-related type charges. And what it basically says is those two people were charged with the same crimes. And in the end, the court didn't sever those matters. We don't have that here right out of the gate. There's no antagonistic defenses. I'm not going to get into factor 3. There's really just overflow and spillover as far as that goes. And so the question is is the evidence against Ms. Powell going to impact her? And the reason I say that is we're charged in the RICO and then 6 predicate acts. The predicate acts only deal with the elector slate as far as who filled out the electors, was that fraudulent or not. With regards to what happened in Coffee County, you're going to have a ton of other charges from witness intimidation, computer hacking, fraud, that has nothing to do with Mr. Chesborough. The other thing you look at is, are these other pieces of evidence going to be similar transactions potentially, which wouldn't be in this case because they have nothing to do with one another. There's nothing similar about it. So when the government argues that it's RICO and we get to bring in anything in the kitchen sink, I think the cases that I'm going to cite you, there's a couple more also from 2023 that talk about, yeah, you can bring in everything, and it's mostly been like gang RICO type cases or some type of violence that's out there. It still gives you an out based on what you think. And the reason I bring these up is in all those cases, everybody's charged with the same things. Here, they can argue that it's a similar activity, but not to speak for Ms. Powell, but essentially from what I understand from the public record is she was fired before this conspiracy actually even started up because she said something that was supposedly crazy and the Trump people got rid of her, and whatever she did was sort of on a lark on her own as far as Coffee County goes. That's just my understanding from the public. Again, I just want the court to focus in on what type of evidence would come in against Ms. Powell versus what we're charged with, which is solely paperwork and legal opinion on 3 different memos and some emails. So with that, I'll approach the court on a RICO case that dealt with drug dealing that just came down in the federal courts in March of this year. It's out of the 9th Circuit. Again, I've highlighted everything that I believe to be relevant with regards to this case.
Mr. Rowe, what's the site on that?
The site will be 2023 Westlaw 2620418. And if Your Honor would look at just above head note 7, it's going to be about 3 or 4 pages in. I realize the bottom of my pages have sort of been cut off, but it would be if you just fold over 3 pages, and I've highlighted it. And so again, there they talk about co-defendants being charged in conspiracies and, you know, why there's a joinder in these matters. But again, factually speaking, if you look at it, the charges are the same against each person, and then the severance isn't necessarily going to change anything as far as that goes. And again, I know I'm repeating myself, but we don't have similar charges. It's completely different if you look at the indictment as far as that goes. Again, I'll emphasize, we are charged solely with the elector portion and the ballots that they filled out that were sent up to Washington, D.C. versus Ms. Powell isn't charged with any of that. She's charged with, I guess, computer fraud and some other things as it goes to Coffee County. And lastly, before I rest on this part of this argument, the seminal case that came down dealing with suppression would have been Zafiro versus United States back in 1993, ZAFIRO. Again, I'll highlight that, Your Honor. And this also is a drug conspiracy because almost all the RICOs and the conspiracies, unfortunately, dealt with drugs and violence, and this is sort of an outlier or a case of first impression for all of us here. And if Your Honor goes to the head notes that are labeled 8, 9, 10, 11, 12, and 13 on the 3rd page over, they talk about the risk of a fair trial in this situation. Again, in Zafiro, they didn't grant the severance because the parties were interacted, and they just mostly talked about antagonistic defenses because one co-defendant would say the other guy did it, I didn't know anything about anything. But they also talk about what evidence could have been admitted that wouldn't be considered against someone else. And so in our position is, if you look at Georgia case law, it talks about would they be similar transactions so they could come in or some other vehicle. None of that exists here in this case. And like Mr. Grubman said, they're essentially different mini conspiracies within this entire RICO Act.
And so what evidence are you pointing to that's inadmissible in your trial than would be in another?
With regards to Ms. Powell, we would object to a lot of that stuff because it would impugn our character as far as being associated with somebody, which they'd have to prove. Now, granted, it's admissible if we're going to trial together, but you would have to give limiting instruction after limiting instruction after limiting instruction as far as that goes. And at some point, if we're going for a week or a month or however long the trial is, I don't want the baby to get thrown out with the bathwater. That's why I'm emphasizing. We are charged with sort of the intellectual part of this case, right? We wrote some memos talking about how the ECA and the 12th Amendment works, and that's a separate motion we filed that we'll need to take up in the future about those issues. And then specifically in Georgia, we sent 2 emails to the head of the Republican Party as alleged. That's it. In the RICO counts, there's 160 some odd overt acts. As the court knows, there's an overt act, which doesn't have to be a crime, and there's predicate acts. We are not labeled as having committed any predicate act in the RICO conspiracy in this case. We then have 6 substantive counts, all that deal with whether the electors are fraudulent or not, and whether they filled out the paperwork was forgery or not. That's essentially all of it. With her, you don't have that. You've got what happened in Coffee County as far as, did we have computer fraud, computer trespass, did we intimidate people, were we suppressing the vote, things like that, that, you know, I've read about and I've seen the public atmosphere which is going to come up. That has nothing to do with us. Our whole point is, we were 1,000 miles away from here. We wrote intelligent memos based on our experience in the Gore versus Bush campaign, which we also worked on. And we basically said, if there is a valid underlying offense, then the ECA and those arguments that I'm making could be valid. We had nothing to do with the actual shenanigans, allegations, whatever, in the state of Georgia necessarily themselves. And that's where I'm trying to distinguish it. Because you could very easily say it's just 2 defendants, so there may not be a confusion of who's what, but you're essentially running 2 trials simultaneously in here. And so I don't think giving limiting instructions with me objecting to all of it is fair. And I think that's what Zafiro and some of the other cases talk about. And I brought those up because even though they ruled against us and everything, the analysis was relatively sound. And in the end, it says you can do what you wish because there is no specific X then Y situation. So that would be my argument with regards to Ms. Powell.
So let me unpack a few of those because so under the kind of traditional 3-prong metric we're looking at, one of the recurring themes is spillover evidence. And if you're saying that essentially what we've got are 2 different trials or 2 different conspiracies that have been joined under this umbrella, and you've said that Mr. Cheesebro never even interacted or knew Ms. Powell in any way, where's the spillover there? If they've actually never interacted and these counts are entirely separate, as you keep kind of pointing out.
Well, the spillover is essentially, I mean, we can't hide sort of the elephant in the room that sort of overglosses all this stuff. I don't know what evidence the government's going to try to present with regards to how they prove the RICO conspiracy or the knowledge or those types of things. What I'm saying is, yes, there's going to be separate evidence going up against Ms. Powell, but at some point, the sheer volume of it all, there's going to be sort of a connection. We're sitting at the table together, and that carries a lot of weight. Your Honors, one of the very few judges that's done a ton of trials as far as that goes, and you know the impact that's going to have as far as that goes. There's just a reality. I don't know if there's a legal theory that says it out there, but you and I both know that's going to happen.
And I'm not discounting that it might be, you know, obviously inconvenient and burdensome, and it might take a lot of time. But do we have any case? You cited to the Price case,
Yes,
I think, as a reversal of a denial of severance.
Yes, sir.
Have there been any other cases in the 43 years since then where a denial of severance was reversed?
It's incredibly rare. I haven't found it. I'm sure somewhere in this country that's happened as far as that goes. But what I was trying to say is severance traditionally, even like when you and I interacted, is in a group of 3 or 4 people accused of committing a crime together, specifically you murdered this guy or you sold these drugs, you did this. It's not you sold drugs, you murdered on a separate day, a month apart, whatever it might be. There's a time lag here. There's a completely different set of facts that go with it. There's no interaction or knowledge as far as the parties go. So there's no way for us to presume how much damage that the evidence against one person might eventually spill over regardless of the instructions. And that's what I cited to you in the Griffin case, you know, out of Georgia from 2000 by the Supreme Court. It's a decision you have to make. I can't presume any of that, but having a ton of experience, you having a ton of experience in trials, you know that that is a substantial risk as far as impacting a fair trial, because her charges are way more provocative versus the boring old charges that we have as far as just sort of the paperwork type situation. And that's what I worry about, because it tinges on racial issues, voter suppression, all those kinds of things are going to come up, you know, based on what's happened in Coffee County. And that scares the heck out of me.
So are you saying that in line with Price, I think the way Price has been distinguished over the years is one defendant had overwhelming evidence and the other defendant didn't really have much. Are you saying there's a defendant here who has overwhelming evidence as compared to your situation?
Well, I don't have discovery yet, so I can't necessarily say. I can just base it on what I think the evidence is going to be. I don't know if I'd call it overwhelming. It's completely different, and I'm sure there's going to be a ton of it from what I've seen in the the TV coverage and the public media as far as people speaking out on Coffee County. Whereas on our side, we'll have intellects talking about, is the ECA constitutional, is it not? What is the 12th Amendment? I mean, frankly, Judge, prior to this case, I didn't even know what the 12th Amendment was because I'd never even thought about it. I don't know if anybody in this room had really thought about it, or the ECA. It was just people vote and somehow it all works out. And so I've had to learn a lot of that stuff. It's just a completely different trial. I think you can see that in sort of reading just the indictment in itself. And that's the fear. At some point, do we just sort of mix it all together and stop paying attention? I don't know. And then how many limiting instructions are you going to give in this case? Is it going to be before every witness that comes up against Ms. Powell, which of course I'll have to object to is not relevant to us, and impeaching and all these kinds of things. And so I just think it'd be easy to have a clean trial. It'd be a much shorter trial, in my opinion, as far as that goes. So that would be my position, and I'll let Mr. Rafferty address it, and then I can address the second issue.
Why don't we just go ahead and, since you're up, we'll talk about severing counts, because that one I wanted to make sure I understood exactly what you were asking for. Are you saying there should just be a redacted indictment if you proceed to trial alone? Or are you saying that the state shouldn't be allowed to introduce any evidence other than what Mr. Chesbrough has specifically been charged with?
What I'm asking for is a redaction, and we typically do that on cases where, we have hearings on certain charges or a co-defendant falls out. If there's multiple murders or multiple drug deals, you sort of block it out. I don't know how else to phrase it except for maybe a severance of counts. We have 7 counts. I get it. I don't necessarily think they're related, but I'm not going to challenge that because the law is weak on those issues. The 34 other counts involve a total of 13 defendants that we're not affiliated with. Our counts are involving 6 total people. But the other 34, again, as Mr. Grubman said, are multiple conspiracies within the conspiracy, and I don't see how that's relevant or even admissible in this case. It's not similar transaction material. So I'm just asking it to be redacted, I guess, if that's the correct word, because we're not being judged on those counts, so we shouldn't be telling the jury all this kind of things, just like you'd redact some of the names in the indictment.
So to be clear, it's more just a logistical thing that the jury would get an indictment that's been changed just to reflect your case, not that they couldn't have witnesses talking about the entire RICO enterprise as they allege it.
Right. I'm not saying that at all. That's a matter of different objections down the road as to admissibility or relevance. But on this matter, I'm just saying the jury shouldn't be seeing the other 34 counts that are out there, or the, I guess, 18 other defendants or 17 other defendants that are out there. I did cite Durden as far as your discretion, but that's, again, more about counts I've been charged with trying to sever something apart. We don't have that time distinguishing. All our actions are within basically 2 weeks. So I'm not going to waste your time with that. I'm just saying what the other 34 counts deal with, the time frames are different, the people are different, the charges are different. And so I would just like a sanitized indictment, whether we go alone or with Ms. Powell, as to those counts, because I think the court can see, obviously, the recent prejudice there, having to read off a 98-page indictment when only, I think, 6 or 7 pages apply to us.
Okay, fair enough. Thank you, Mr. Aurora.
Yes, Your Honor. And will I be able to rebut if the government chooses?
Let's see where we go.
Okay.
Good afternoon, Your Honor. The case against Ms. Powell is in a slightly different procedural posture than against Ms. Chesbrough, and I just thought it appropriate to sort of start with the fact that we filed a speedy trial demand within a day or two of the speedy trial demand of Mr. Chesbrough, and we have not yet received a scheduling order or a ruling or anything else about when the trial of Ms. Powell will occur. My experience as a former federal prosecutor and in federal court under the Speedy Trial Act is in situations where you have multiple defendants like this, if one defendant makes a demand for a speedy trial or 2, as we have here, the court has the discretion under the Speedy Trial Act in federal court to still push the case down because some other defendants, as we have in this case, have said they're not ready for trial. That's ordinarily what happens in federal court. But here in state court, looking at the state law and the state Speedy Trial Act, by virtue of our demand and the various severance motions that other defendants have filed saying they're not ready for trial, I think Ms. Powell has to be severed out from the remaining 17. And so the question for today, in my mind, is whether the trial of Ms. Powell will be joint with Mr. Chesbrough or not. I think based on all of the law that I've seen, and I haven't seen anything to the contrary, her demand for speedy trial cannot be trumped by the desire of the government to try everyone together when other defendants have moved to sever and said they're not ready. And so that's sort of the first point I wanted to just make is although the court hasn't issued a scheduling order, I think we are on the same path as Mr. Chesbrough about when this trial should happen, which leads us to sort of the second question about whether or not Mr. Chesborough and Ms. Powell should be tried together. And I echo many of the things that my co-defendants counsel have said, although I have a very different view of the evidence and the evidence as it relates to Ms. Powell. I'll just point out in the indictment, the government was kind enough to list on page 16 or 17 or 18 a summary of the various manner and means of the indictment. And if you look at that, you'll see that Ms. Powell had nothing to do with most of it. Ms. Powell had nothing to do with false statements to state legislators, nothing to do with false statements to high-ranking government officials, nothing to do with false electoral college documents, nothing to do with the election worker here in Fulton County, nothing to do with solicitations of the Department of Justice, nothing to do with solicitations to the vice president. The only thing which she's alleged to have involvement is, as my co-counsel have said, is this Coffee County matter. And frankly, Your Honor, the way the government has characterized that, the evidence is going to show they're incorrect. She was not the driving force. The evidence will show that she was not the driving force behind that there were other lawyers not mentioned in this case that were actually the driving force behind that. We've submitted a Brady request already to the government before this hearing, asking for a host of different kinds of exculpatory material that we believe the government has that will show that. That will show that she was not the person that was behind this, has been alleged in this indictment. Her typewritten name does appear on a contract, but she never signed the contract, and the contract isn't even for Coffee County. It's for another state, and she never signed it. And the most important part of this case, Your Honor, with respect to the Coffee County aspect of this case, is the question of authorization and whether or not the visit down there was authorized or not. And there's a lot of public documents that are out there that demonstrate that numerous folks associated with Coffee County authorized that visit. The video itself shows that. Ms. Powell's name appears maybe a dozen times in this indictment. She has nothing to do with the electoral college aspects of this, which is going to involve all sorts of complex testimony about constitutional issues and things of that nature. Her only involvement, as alleged by the government, is what happened in Coffee County, and even that they have wrong. So why does that matter? Because my presentation, my cross-examination, my case is going to depend on my ability to present to a jury that she had nothing to do with what the government says she was involved in Coffee County. The evidence is not going to show what they say. But all of that, all of my efforts, is going to get washed away in days or weeks of testimony, perhaps, about the Constitution and whether or not and under what circumstances alternative electors can be put in place and whether the legal opinions of Mr. Chesborough and others have any sort of legal validity. All of that is going to be prejudicial to my client. She's going to be sitting there for days, if not weeks, listening to this kind of testimony when the case as to her in Coffee County really boils down to one day, January 7th. That's it. The whole case is about whether or not that visit was authorized and what, if any, role she had in it, which is very little, if none. So, you know, she's going to be prejudiced by all this other testimony about things that she had nothing to do with. And as a matter of judicial economy, you have discretion, as my counsel have said, you have the discretion to make a decision about the interests of judicial economy. I don't think a trial about Coffee County, if that's what we have a trial about, is going to take weeks or months. I think the trial could be over in a couple of days. Most of it is on video that a lot of folks have seen, and there's a handful of emails, and that's really it. There isn't that much evidence. And so when the court thinks about its discretion, about how it can exercise that discretion and move this case along, move Mr. Chesborough's case along, the best way to do that, frankly, is to try the cases separately. And I would ask the court to just exercise the discretion that it has, that my co-counsel have already set forth, and sever Ms. Powell's case from Mr. Chesborough so she can get a fair trial. I'm prepared to answer any other questions, Your Honor. I think I've laid out my arguments.
Let me take up one, again, as it relates to the traditional framework. I think Mr. Chesborough's team took this up, but one of those, obviously, is the antagonistic defenses. Are you joining their position that you don't anticipate that being a consideration here?
I don't think that there's antagonistic defenses because, as my co-counsel has said, my client doesn't know Mr. Chesborough, has never met him, has never really spoke with him. There's no emails or documents or anything else. What he's accused of has absolutely nothing to do with Ms. Powell at all. And so I don't see that as antagonistic. It's just that evidence presented at a trial with Ms. Powell is going to prejudice her in the same way that Mr. Chesborough's lawyer said that evidence about whatever Ms. Powell did would prejudice Mr. Chesborough.
Okay.
Thank you, Your Honor.
Thank you, sir.
Say that she was fired.
That's why Mr. Wooten is chomping at the bit to address some of the arguments that counsel has made. I'll just briefly lay out a few things that the court has asked the state to be prepared to respond to. Firstly, we will contend that a trial of these 19 co-defendants will take 4 months, and that does not include jury selection. And it's also predicated upon whether or not, of course, the defendants elect to testify or not. But 4 months is our time estimate. In terms of the number of witnesses, there are in excess of 150 witnesses that the state intends to call. 150 witnesses. Judge, we contend that we must prove the entire conspiracy against each and every one charged. Each and every one charged. So the court, in the interest of judicial economy, would have to make the decision as to whether or not the court wants to try the same case 19 times or 2.
So, to be clear, when you say 2, has your position evolved from your filings of last week or from lately?
It hadn't. It hadn't, Judge. I just throw out the number for just to give the court the difference in the number of times and the number of man hours it'll take to try the case, once or twice.
Well, when you say twice, who's involved in each case?
Obviously, the 2 who have requested severance here.
All right, because up to this point, I thought the state's position was all 19 need to go on October 23rd.
It is, and that continues to be our position.
Okay. And just to clarify that and flesh that out a bit, you're saying that right now you would predict that if it was just a trial of Ms. Powell and Mr. Chesbrough, that the state's going to need those same amount of witnesses, those same amount of exhibits, and that same amount of time?
Absolutely.
Okay.
Your Honor, for my portion, I do have a PowerPoint. How does the court prefer that I do that?
Well, I think we'd have to get you on the Zoom call so you could share a screen.
Okay. Just a moment.
Do you have a link for that?
I do not, Judge, but
All right, let's see if we can email you that.
Does the government have a paper copy of the PowerPoint that it can share with counsel?
yes. While I'm waiting on that email. Judge, I'm not seeing that email come through.
Just hold another minute.
Your Honor, if we're using, I'm sorry, is it all right? I'm sorry, I had knee surgery 2 weeks ago. So, could we just make the PowerPoint an exhibit if the government's going to use it to the record?
We want to make it an exhibit? That's
I would ask
objection here with this S1?
No objection, Your Honor.
All right. Do we have an extra copy for Ms. Smith?
We could share ours. I can share with Mr. Rafferty if they don't have an extra copy. So
Judge, I did have a copy for the court, but I could convert that to an exhibit if the court prefers.
Sure.
Judge, I've got the meeting ID. I just don't have the passcode.
Stand by for another email.
I've actually got it right here, Your Honor. Judge, may I go ahead and share screen? Your Honor, I'm just going to quickly move through, of course, the statutory and case law parameters under which Your Honor has to make this decision. 1784A, of course, states that when two or more defendants are jointly indicted, such defendants may be tried jointly or separately in the discretion of the trial court. And our case law, we're relying on Collins versus Estate 312, Georgia 727. Three factors to consider are the likelihood of confusion of the evidence in law, the possibility that evidence against one defendant may be considered against the other defendants, and the presence or absence of antagonistic defenses. And I guess the position of the other side is that neither is saying that three is an issue, that there doesn't seem to be any antagonistic defense. Of course, neither the mere presence of an antagonistic defense nor the possibility that a separate trial will give a defendant a better chance of acquittal is sufficient to sever. The defendant bears a burden of showing that a joint trial would be so prejudicial as to amount to a denial of his or her right to due process. So I want to talk about what's not a proper ground for severance first. And this is coming from Mr. Cheeseborough's motion to sever. He says, in sum, there has never been any direct contact or communication between Mr. Cheeseborough and Ms. Powell. Similarly, there is no connection or overlap between the overt acts or the substantive charges associated with Mr. Cheeseborough and Mr. Powell. That is not a defense, and that is not a ground for severance. Similarly, Ms. Powell's motion says that Ms. Powell can receive a fair trial only if she's tried alone. The prejudice that would inure to her from a lengthy trial with any of those she was not involved with and about the vast number of events she had no knowledge of or connection with would deny her due process. Again, not a defense, not a ground for severance. Turning to case law, Lowry versus the state, 347 Georgia App 26, a 2018 case. Nothing in Georgia's RICO provisions requires that Lowry, the defendant in that case, have participated in or even been aware of all the alleged acts of racketeering activity committed in connection with the common enterprise. Thompson versus the state, also Georgia Court of Appeals. None of the provisions of the Georgia RICO Act requires that each defendant in an enterprise have full knowledge of all facets and elements of the enterprise and all of its members or actors. And likewise, the federal courts agree. This is an 11th Circuit case, 1996, United States versus Castro. In proving the existence of a single RICO conspiracy, the government does not need to prove that each conspirator agreed with every other conspirator, knew of his fellow conspirators, was aware of all the details of the conspiracy, or contemplated participating in the same related crime. And so we've heard a lot from both defendants about they didn't know the other people. They were located thousands of miles apart. They didn't even know that the other parts of the conspiracy were going on. But the case law is clear that that does not matter. Of course, anytime a person enters into a conspiracy, they are liable for all of the acts of all of their co-conspirators. And that's it. Evidence against one is evidence against all. And as Mr. Wade noted to the court, the state's position is that whether we have one trial or 19 trials, the evidence is exactly the same. The number of witnesses is the same. And so many of the arguments that are made on the other side evaporate. I want to look at the cases that were cited by Mr. Cheeseborough in his motion. Griffin versus the state, that's a case where severance was properly denied. It is not a RICO case. Brown versus the state, another case where severance was properly denied, not a RICO case. Baker versus the state, severance was properly denied, not a RICO case. Padgett, severance properly denied, not a RICO case. Jones versus the state, severance was properly denied, also not a RICO case. Zafiro versus United States, federal case. Again, severance was properly denied. That was not a RICO case. Henderson, which we just received just now, that was also not a RICO case. Severance was properly denied. Mr. Cheeseborough points to a couple of cases in his motion where a conviction was reversed on appeal. And as the court pointed out, in those cases, what the appellate courts found was that at trial, the evidence against one defendant was minimal, almost nothing compared to the evidence against the co-defendants. And so it was just fundamentally unfair that there was all this evidence that applied to one, very little that applied to the other, and the jury may have been confused. Look at Defendant Powell's list, and most of these are the same, so I'll click through them. Again, same cases, most of them severance properly denied, none of them a RICO case, and the ones where a conviction was overturned on appeal, again, it came down to insufficient evidence at trial. The evidence against the defendant named was just so minimal compared to the evidence that was pertinent to the other defendants charged. And of course, conspiracy cases, and more specifically, RICO conspiracy cases, are different. And that's why we point out that all of those cases relied on by the other side are not RICO cases. And so the analysis is different. The facts are different, and the law is different. Looking to our Georgia courts, Pasha versus the state, 273 Georgia App 788, 2005 case. Each actor in a conspiracy is responsible for the overt actions undertaken by all of the other co-conspirators in furtherance of the conspiracy. Willingham versus the state, Georgia Supreme Court case 1995, where there's sufficient evidence of a common scheme or plan to commit a criminal offense, joinder is authorized. And our federal courts kind of take both of these concepts, and in United States versus Caporale, 806 F. 2nd, 1487, an 11th Circuit case here in Atlanta in 1986, joinder of co-defendants in a count charging a single RICO conspiracy violation is permissible, even if different defendants are charged with different acts of racketeering, if the racketeering acts charged are in furtherance of the overarching RICO conspiracy charge. And in our case, the state's theory of the case, and as laid out in the indictment, each and every one of those 161 overt acts charged, and all of the offenses charged from count 1 to count 41 were all in furtherance of the same overarching RICO conspiracy, which was to unlawfully affect the outcome of the 2020 election in the state of Georgia. Every single one. I understand the other side's argument that, my clients over here in Coffee County, my clients over here in Wisconsin or wherever sending off emails. But the problem for them is that it doesn't matter because it's all part of the same overarching RICO conspiracy. And the state's theory of the case, as alleged in the indictment, is that as this enterprise operated in multiple states and operated quite a lot in Fulton County, that's why we have this case here in Fulton County, the conspiracy evolved. One thing didn't work, so we move on to the next thing. That thing didn't work, so we move on to the next thing. That thing didn't work, so we move on to the next thing. And that was going on from the first overt act to the last overt act, all part of that same overarching RICO conspiracy. Turning back to the factors that the court needs to look at, and I'm just going to kind of talk about factors 1 and 2, the likelihood of confusion of the evidence in law, and the possibility that evidence against one defendant may be considered against the other defendant. Of course, 3, which the other side agrees is not an issue here. But 1 and 2, because this is a RICO conspiracy case, and because the evidence against one is admissible against all, 1 and 2 evaporate. There's no likelihood of confusion about which evidence applies to which defendant or which law applies to which defendant when all of them are alleged to have engaged in the same conspiracy. And it's significant that in count 1 of the indictment, the RICO count, the allegations set forth in counts 2 through 41 are all included in that count 1. And so while, Mr. Cheeseborough may have never been to Coffee County, the evidence about Coffee County is evidence that the enterprise existed and shows that the enterprise was working. And because it's a conspiracy case, Mr. Cheeseborough is liable for what happened there, and it's admissible evidence. Again, going back to our federal court, since any evidentiary spillover, and the court asked about this issue, since any evidentiary spillover is vitiated where the evidence in all events would have been admissible against the movement, in the context of a conspiracy, severance will rarely, if ever, be required. This is a First Circuit Court of Appeals case, and we submit that as persuasive authority here. Again, turning to another example, United States versus Diaz, a Second Circuit case from 1999, and a federal RICO conspiracy case from the Second Circuit involving the Latin Kings. Even when a defendant was implicated in only one of 9 separate murders carried out as part of a pattern of racketeering activity, a joint trial was proper because all of the evidence was admissible against each and every one of the defendants to show multiple things, not just that they committed an act, but to show the existence and nature of the RICO enterprise and to show a pattern of racketeering activity on the part of each of the RICO defendants, as well as his or her relationship with the enterprise itself. And I just love this quote because I think it sums it up. Again, it's an 8th Circuit Court of Appeals decision, persuasive authority, but there in United States versus Kehoe, the 8th Circuit said that it will be the rare case, if ever, where a trial court should sever the trial of alleged co-conspirators. The other side pointed a little bit to this, but I did want to mention that any potential jury confusion can be addressed by other means other than severance, such as an instruction to the jury to separately consider the evidence as to each defendant. Now, again, the state's position is that because this is a conspiracy case, because it's a RICO conspiracy case, that all of the evidence is admissible against all of the defendants. But even if that, even if there were some issue or to be extra cautious, the court could give a limiting instruction. And the state's position is that it would not be limiting instruction after limiting instruction after limiting instruction, because again, all the evidence is admissible against all the defendants. Also, the defendants completely ignore a long line of cases in Georgia that affirm the denial of severance for Georgia RICO Act violations, all decided under these same principles that I've just talked about. First, Chancey versus the state, Georgia Supreme Court, 256 Georgia 415, a 1986 decision. Evans versus the state.
I think we've got the cites here. We can look at those later.
Sure. And those are provided to counsel, and I have copies of those as well for you. So under these principles, the defendants cannot satisfy the first 2 prongs likelihood of confusion of the evidence in the law, the possibility that evidence against one may be considered against the other, because that's allowable. That's exactly what a RICO conspiracy case is allowed to do. I don't think I need to talk too much about the third prong because of the statements of the other side. Just would hit that defendant has to show that a joint trial as it relates to the third prong would have to amount to some sort of a denial of a due process right. And we don't believe that's the case here. Palmer versus Estate, just to point out a few, Georgia Supreme Court case where the Palmer court highlighted certain situations where there was no antagonistic defense, Barge, Metz, Lauren, and again, won't get into those because of where we're at. But the bottom line there is that it has to be prejudicial as to amount to a denial of his or her right to due process. I also want to talk about public policy. Public policy, and our courts have hit on this issue, strongly disfavors severance in complex conspiracy cases for several reasons. One is judicial economy. There's been arguments on the other side that somehow severing any of these defendants out would be more economical. I'm not quite sure how that works. I think one 4-month trial is shorter than multiple 4-month trials. Same witnesses, same evidence. Minimizing the inconvenience and trauma on victims and witnesses. And I want to remind the court that part of this RICO conspiracy involves victims. There are victims in this case that were targeted by members of the enterprise, and their lives were turned upside down. And that's an important part of this case, and having those people come and testify multiple times over and over would both inconvenience, but more importantly, traumatize them. Consistency of the verdicts. And I've got a little bit of case law that talks about that. Efficient use of state resources and fundamental fairness. Justice Scalia astutely observed, it would impair both the efficiency and the fairness of the criminal justice system to require, in all these cases of joint crimes where incriminating statements exist, that prosecutors bring separate proceedings presenting the same evidence again and again, requiring victims and witnesses to repeat the inconvenience and sometimes trauma of testifying, and randomly favoring the last tried defendants who have the advantage of knowing the prosecution's case beforehand. He goes on to say, joint trials generally serve the interests of justice by avoiding inconsistent verdicts, enabling more accurate assessment of relative culpability. And he points out that these are sometimes advantages that operate to a defendant's benefit. So even apart, he says, from these tactical considerations, joint trials generally serve the interests of justice by avoiding the scandal and inequity of inconsistent verdicts. And our Georgia courts agree. They agree that economic use of resources is an important and legitimate concern. Montgomery versus the state, 156, Georgia App 448, a 1980 case. In a case where the same witnesses, the same evidence, and the same charges would be used against all defendants, thus affecting judicial economy in the use of physical facilities, time of witnesses, jurors, and court personnel. The trial court must consider these efficiencies against the possible conflicting interests of joint or multiple defendants. And the 11th Circuit, again, agrees. United States versus Brown, 2007 decision 505 F3rd 1229. We find considerations of judicial economy to weigh heavily against severance in light of the substantial systemic interest in handling this complex conspiracy case in one trial. And in that case, it was a 2-month trial. State, as we've represented to you, Judge, believes that this would be at least a 4-month trial. So defendants, the state's position, have not met their burdens as to any of the factors set forth in Collins. The case presents no likelihood of confusion of the evidence or law applicable to any defendant because all of the evidence is applicable to all of the defendants. All of the law is applicable to all of the defendants. And 2, evidence against any defendant may properly be considered against each of the defendants in a RICO conspiracy case, so there's no risk of this spillover effect. Just to mention 3, again, they concede that that's not an issue here. That's all I have, Judge, unless you have any questions.
Just a few. So these, again, the 3 factors, those are just, would you agree that those aren't exclusive?
Yes, Your Honor, absolutely.
All right. So we're really supposed to take into consideration the circumstances of the entire case and anything that just might be present in this case. It may not be in others, right?
Yes, Your Honor.
So I guess some of the things I think we need to think through, to me also, it's more this position that we still need to have all 19 people at the table 47 days from now. And maybe this is something, if you need to tag team in with somebody else on the council, one of the first things I kind of want to talk through is potentially how removal affects this. So I know your state is currently litigating this issue with multiple of the co-defendants in federal court. And while that's happening, until a decision is made, we can't issue a judgment of conviction here, right?
Yes, Judge.
Now, no matter how Judge Jones rules, isn't either party going to have the right to appeal that ruling?
That is correct, Judge. Our position is that both sides would have the right to appeal.
And so the 11th Circuit could take any idea of how long to weigh in?
As long as they need to.
Right. So it could potentially, even optimistically, be a 6-month turnaround just for the 11th Circuit to come up with a decision, right?
Yes, sir.
So if it's a 4-month trial that starts in October, we're potentially sitting at a point where we've presented the entire state's case. Maybe even the jury has returned a verdict, but we can't enter that judgment of conviction until the 11th Circuit comes to a decision. Is that kind of the scenario we're playing out here?
Judge, I think...
Excuse me, if we can have a moment, Judge.
Your Honor.
And by the way, let me add, I know this wasn't something that I highlighted, so if this is something we need to submit for, post-hearing briefing, we can do that, but this is something that I think is a consideration we ought to be taking into mind.
Sure, and that may be the best route, Judge. Our kind of position on that is it depends on what the scope of Judge Jones's order is. If he takes the position that he removes everyone, or that he just removes those who may have, some entitlement to removal, the law is a little unclear on how that works in a criminal case.
But you can see what would happen. No matter how he rules, if let's say he says that some aspects of the case stay behind with us here in Fulton County, and the 11th Circuit changes their mind and reverses that entirely and says, no, the entire case has to get removed to federal court. Where does that leave us in the middle of a jury trial? Is double jeopardy attached? Have you now risked your entire prosecution because this case has now been removed to federal court and we've sworn in a jury and it's been presenting evidence against all these other co-defendants?
Judge, again, I think for those very complex kind of fine-tuned details, we may need the opportunity to brief those issues.
It's not easy. And we've got, again, less than 2 months to figure this out. So I think to kind of charge ahead without coming to some thoughts on this very soon might be risky. And then the other issue here is even if we say that the 3 prongs aren't met, again, just dealing with the logistical issues, the state's case may take 4 months, but voir dire with 19 defense attorneys is going to be a different animal than voir dire with 2. So I don't think saying they're both going to equally be 4 months, no matter how many defendants are involved, would be completely accurate. Is that fair? In terms of who can object, just at any particular question that's asked, the sidebars that are requested, just the sheer physical limitations if one attorney gets sick. Is it really so? Can we so confidently say that each trial is going to be exactly 4 months, no matter who's involved?
I don't think we can say exactly, but I think it kind of cuts both ways, Judge. Because if we had, for example, 19 people tried at one time, you have a witness up, and let's say they're subject to 19 cross-examinations. Of course, each of those 19 is not going to be the same full-length cross-examination. So you would have kind of a shorter, if you took them all together, you might have a shorter time for that witness on the stand with 19 people versus if you have 19 trials of one person. And I'm going to the extremes just to demonstrate the point. But if you have 19 trials with one defendant each, then each of those each of those witnesses would be fully cross-examined 19 times. So there's a give and a take. Some things might take longer, some things would be quicker.
So the other things to think in mind is this is going to be a case with a lot of pretrial motions. And again, I don't know how many hearings we're going to need to have to sort through all those. But if we compress our timeline to 40-something days, our ability to even be able to really weigh those and think through these issues, again, it just seems a bit unrealistic to think that we can handle all 19 in 40-something days. That's my initial reaction. Thinking of just how to get this, and are we even delaying the inevitable? If we say there's no severance, aren't we going to have 17 defense attorneys get up here and file motions for a continuance just saying they're not ready? I think we've already had some counsel indicating they're on trial in other cases in federal court. And if we're just going to be sitting in a position where we're having to consider a continuance motion in 40 days, why delay the inevitable?
Sure, Judge. The state's position on that is that we're here on two defendants. And so at this juncture, other defendants have filed their motions for severance, and they may raise those issues. And it would be appropriate for the court to consider all of these issues in making its decision. But for today's purposes, we're here on two defendants. And the issue is, do we pull these two defendants out? Not do we pull, defendant 13 out or whatever the case may be. So the state's position is until those are raised by those parties, once we have hearings on those, that they shouldn't affect the court's decision as it relates to these two defendants.
Okay, so at a minimum, I think what I'm hearing here is that it might be appropriate at this time to consider whether Mr. Chesbrough and Ms. Powell proceed alone together.
Whether they have provided the court and met their burden to show that they should come out. Not that the other 17 should come out, but they should come out of the pot is the state's position.
Okay. All right.
Your Honor, may
Sure.
I have like 2 minutes to respond?
Sure, last word from the defense since it's your motion.
So, Judge, I will take this down.
Your Honor, I'm not trying to oversimplify this because it is a complicated case, both factually and procedurally. However, as to the 19, Your Honor, there can't be a trial of 19 people, and it has nothing to do with the length of time. It has to do with the fact that two defendants exercised their statutory right to a speedy trial, and 17 other defendants, many of whom's lawyers are here, didn't. And that's our right to do, and that's their right to do. So, with all due respect, Your Honor, I don't even know that there's truly a reason to spend much time. Of course, I can answer any questions, but really much time talking about 19. So really, I think the question here today, to wrap up, is whether it's a trial of State versus Powell and Chesbrough, or two trials, one State v. Chesbrough, one State v. Powell. All of the cases, and we would like an opportunity, since there will be some post-hearing briefing, to read those cases the court State cited and maybe respond to them. I looked at one. It's the one that says, where there is sufficient evidence of a common scheme or plan to commit a criminal offense, joinder is authorized. Willingham v. State. Joinder is authorized. That doesn't mean that severance is inappropriate. Those are not the same thing. Just because joinder is authorized does not mean the court shouldn't sever. Let me be clear about something, Your Honor. The state wants this case, and I think it's absolutely clear in the pleadings. The state wants a case against Donald Trump and all these people together. The state wants to make this case about Donald Trump. Donald Trump is one of 19 defendants. Ken Chesbrough is another one. Ken Chesbrough is not a politician. Before 6-7 months ago, he was probably unknown to 99.9999% of the population. You get all those nines? And so now to force him to sit here in a trial where there's evidence of all these other things is just not fair. And I'm sorry, Your Honor. You know, they have a slide here. RICO is different. Sure, it's different. I acknowledged that in my opening. But what this slide does not say is that RICO overrides the rules governing fundamental fairness, constitutional and statutory protection that are designed to protect defendants. This Willingham case, and upon information and belief, I believe most of the other cases cited by the government, are cases like murder. The Willingham case is a murder case. It's a murder conspiracy case. Certainly the state understands the difference between 3 and 4 people being charged with one single conspiracy versus 19 people being charged with 3 or 4 different conspiracies. And Your Honor, if the court were to take the state's arguments at face value, there would almost never, if ever, be a RICO case that can ever be severed. And think about what that means. It means that the state of Georgia and the various district attorneys throughout the state can use the RICO statute, can take 3, 4, 5, 6, 7 different conspiracies, and at their sole discretion, with no oversight by any court, say that they're one, bring them in one indictment, and then we're all stuck together. And quite frankly, Your Honor, let's compare and contrast this to the YSL case going down a few, I don't know if it's floors down or up, I think down. That YSL case, I don't know much about it, but I know enough. I've watched it TV, listened to podcasts. It's a common conspiracy. Yeah, there were different overt acts being done towards the same conspiracy, and therefore the state can try them together, but it's one conspiracy. And that's where I think if you read that Willingham case, where there is sufficient evidence of a common scheme or plan, how, Your Honor, is the plan down in Coffee County, if it's a plan, the alleged plan, have any commonality other than electing Donald Trump, Your Honor? Half of the United States took some act towards electing Donald Trump. If that were the only thing that mattered in terms of connecting all these as a common conspiracy, there would be no rules of due process. And the last thing I'll say, Your Honor, is I will go back to what we said at the beginning. I think it's perfectly clear here that this trial does not have to last 4 months. Because what the state is assuming is that, let's say Your Honor grants our severance motion and allows us to try our case just Chesborough and then Powell separately. Well, they're saying, well, it's all going to be the same evidence. Not necessarily. Obviously, the time hasn't come to file motions in limine, but we will obviously file motions in limine regarding the admissibility of certain evidence, certain extrinsic evidence of other acts that we don't think are relevant. And we have the other motion to sever the counts. And no one motion, I don't think, Your Honor, should be, they all, obviously, I know the court has to rule on all of them independently, but I would argue, Judge, that you should consider them jointly in terms of figuring out the big picture here, which is, it is within the court's control to...
Well, let me clarify something, because I think the argument of the motion to sever the counts really wasn't so much as a ruling on
Yes, Your Honor.
limiting the evidence, just as a logistical, here's the indictment we're going to hand the jury.
And I meant all together. So if you combine, let's say Your Honor was to grant that, it would be a significantly pared down indictment. Then, assuming that we're going to file motions in limine that kind of track the same type of arguments, right? The things that I know Your Honor is not going to rule on this until we file it, but you might expect that if Your Honor grants a motion that says, all right, these 50 things in the indictment don't get read to the jury, it's probably a pretty good chance either way that we're also going to file a motions in limine to say that evidence of those things that have nothing to do with Mr. Chesborough also can't come in. Your Honor, the bottom line is the state cannot be allowed to call something RICO and the rules are out the window. It wasn't what the General Assembly intended. It's not consistent with just basic principles of due process and fundamental fairness. With that, Your Honor, unless the court has any questions, we appreciate it, and I reserve the remainder of my time to the extent there is any.
Mr. Rafferty?
Very briefly, Your Honor. I just want to... We've beaten the dead horse as it relates to your discretion about granting a severance between Mr. Chesborough and Ms. Powell. But the first point I made, I think, remains, and that is Ms. Powell has filed a demand for a speedy trial much in the same way as Mr. Chesborough. Many of the defendants, as counsel has indicated in the courtroom here today, their lawyers have filed motions to sever. And I don't think any of the case law or anything that the government has cited here today trumps my client's right to a speedy trial. She has asked for a speedy trial. She filed it timely, just like Mr. Chesborough. Therefore, I think, at a minimum, her case is severed from the remaining 17. It must be severed because none of the cases that the government cited point to the idea that all of those considerations trump the statutory rights of my client to a speedy trial. So, we can see what post-briefing comes in about severing Mr. Chesborough from Ms. Powell, but I don't think there's any dispute at this point that Ms. Powell and Mr. Chesborough are severed from the remaining 17 based on our demands for speedy trial.
All right. Thank you, Mr. Rafferty.
Your Honor, just briefly, just for the purpose of the record, I want to make clear that there is a dispute about severing the 2 from the 17. I think the state's made that clear, so I just want to make sure that that's cleared up for the record. There's some statement on the other side. And just before we depart, we would just ask for if there is briefing, what that briefing schedule is.
Of course. No, I think we still have plenty to talk about before we wrap up for today. So, obviously, I think as has been made clear, we're on an expedited timeline with these statutory speedy trial demands, and we are certainly here ready and willing to provide both defendants that right, and we plan to make that October 23rd trial date stick. With that in mind, I don't know if we're always going to be able to have the luxury of pre-hearing briefing and post-hearing briefing, and some of these issues may require a little more exploration than others. This one, I don't think is one of those. When it comes to the question of whether to sever Ms. Powell and Mr. Chesborough, I certainly agree that there are always guardrails, and that RICO, as indicted, can't just be used to do anything, but it is broadly construed, and those guardrails are found in those 3 factors. And the 3 factors traditionally that we've gone through really don't seem to be at play here. We don't, for one, the antagonistic defense issue is conceded. Both parties are going to be claiming they have no idea who the other is and won't be pointing the fingers at each other. I think the argument that they're charged in 2 separate kind of silos of charges strengthens the idea that there won't be confusion amongst the jurors and there won't be spillover evidence. So really the strongest thing that I'm hearing, and I don't think it's invalid, is that it's going to be kind of a matter of inconvenience and potential added expense to have both defendants sit together. And that's certainly true, but there's also other judicial economy aspects to consider and issues of inconvenience as well. We talk about the jurors. I don't think we can take for granted that these would both be 2 equally 4-month-long trials. I think it could easily be twice that with multiple defendants, and I think we need to take into account the fact that one docket goes entirely on hold while this case is going. And instead of it being, if we're purely considering aspects of judicial economy, which to me was really the only valid argument here, I think taking up 2 dockets and for a period of 4 months also weighs into that, as well as the voir dire process and the inconvenience to the jurors. So based on what's been presented today, I'm not finding that severance from Mr. Chesborough or Powell is necessary to achieve a fair determination of the guilt or innocence for either defendant in this case. And so I'll deny Mr. Chesborough's motions to sever from Ms. Powell. I'll deny in part Ms. Powell's motion to sever from Mr. Chesborough. And the plan will be to enter a scheduling order for Ms. Powell mirroring that of Mr. Chesborough with the October 23rd date holding. It sounds like the state is still sticking to the position that all these defendants should remain, and they want to address some of these removal issues. I'm willing to hear that. I remain very skeptical, but we can. I'm willing to hear what you have to say on it. And so, but again, because we're on a limited time frame, I don't think we have the luxury of waiting. So, how long do you think the state needs to respond to that issue?
2 weeks, Judge?
I don't think we can do that. There's going to be motions deadlines for the other defendants, and we need to get scheduling orders entered.
Had to ask.
That's fine. And I had to deny.
Understood. 10 days?
Well, I think the 10-day mark from today. I know, again, I'm sending the indicator that folks are going to have more than 10 days to file their standard post-arraignment motions. Let's see if we can have that by Tuesday of next week. Again, this is limited to how you think logistically we could possibly keep these defendants together, and I think we can limit that to 10 pages. And if anyone else wants to respond, they can to that issue. But Mr. Grubman?
Yes, Your Honor. This is, if you're still going on this issue, I did have a quick other issue just since we have your attention to bring up. We do have a pending motion to talk to the grand jurors.
Right. Let me get to that. So, again, knowing that Mr. Chesbro and Ms. Powell are hurtling forward and the motions are going to keep coming in, I don't think it makes sense to just have these all pile up. So we would pretty much maybe just keep having these weekly sessions together and handle them one at a time. So to that end, I believe we're starting another trial next week. I think it's a murder trial we're doing next week, but looking at Thursday or Friday of next week, how's everyone's availability? I only saw motions from Mr. Chesbro, so I guess the question's only directed towards Mr. Grubman and Mr. Aurora. I'm looking at Thursday or Friday morning.
We're here whenever the court instructs us to be.
Got it.
Your Honor, could we ask for Friday morning? I've got to do a sentencing.
On Thursday morning?
Afternoon.
Thursday afternoon?
You know, Florida State Howard's going to be free, so I just figured if we could have, depending on how many motions, just
Well, so far you've got, I believe it's the two related to the grand jury, and then you have one more related to the supremacy clause.
we've got two more coming either today or tomorrow.
Maybe we limit it, since the grand jury issue is something that might take more time to flesh out if it's granted. Maybe we limit it to those two for next week, and we can save the constitutional arguments for another day. Can we still do that Thursday morning, though? Assuming if it's just those two related to the grand jury.
We start at 9.
That's the plan.
Okay.
Yeah.
Thursday morning,
I'm sorry, John. For the record,
Sure.
Thursday morning or Friday morning?
Thursday morning, it sounds like everyone, and we'll do those two grand jury motions. And then, Mr. Rafferty, if you want to jump on board and adopt them, we can obviously work you in.
Yes, Your Honor. And just quick clarification, the briefing from the state by Tuesday, is that going to be on the question of whether it's going to be a trial of 19 or a trial of 2?
That's right.
Thank you.
Nothing else from Mr. Chesbro at this time, Your Honor.
Okay, thank you, Mr. Grubman. Anything else we should address since we're all here together?
Real quickly,
Sir, yes, sir.
some of the lawyers for some of those other defendants are in the courtroom may well have an interest in the issues and the arguments that the government makes about whether it's a trial of 19 versus a trial of 2. So are those other lawyers permitted to submit some kind of briefing in response to whatever the government says?
I think that would be fine. I think some already have. I think folks have already been submitting severance motions saying that they're not ready, that there are conflicts, and so that might very well suffice. But certainly, I'm not going to foreclose that opportunity if they want to be heard in more detail. So we'll send out an email to everyone indicating as much.
And relatedly, then on Thursday morning, would we potentially have some discussion of that motion as well? That briefing?
We can. Again, I think by then I'm hoping to have already ruled and issued some scheduling orders because we need to get that clarity so we can focus on what lies ahead. Anything else?
No, Your Honor.
Okay. Anything from the state? All right. Thank you all. See you next week.
Thank you, Judge. All right,
Oh, no, man. How are you?